These are appeals in the matter of Maynard and others and Thames Water Utilities Holdings.
Yes.
May it please your lordships, I appear on behalf of the Class B AHG alongside my learned friends Mr. Singler KC, Mr. Abraham, Mr. Mustafa and Ms. Beltrami. The Class B AHG are an ad hoc group of holders of Class B debt.
Yeah.
Within the WBS structure of the group, we are secured creditors. My learned friends, Mr. Thornton and Miss Peters, appear on behalf of TWL.
Yeah.
TWL are outside the WBS structure.
Yeah.
They are unsecured. My learned friends, Mr. Day, Dr. Mokel, Mr. Cock, Miss Davis and Mr. Jones, appear on behalf of Mr. Maynard MP.
Yeah.
Mr. Smith, Miss Cook and Mr. Shaw appear on behalf of the Plan Company. Mr. Al-Attar and Mr. Lupi appear for the Class A AHG, who are holders of the Class A debt. Within the WBS structure of the group, they are secured creditors. To avoid duplication in submissions,
Yes.
I intend to address your lordships on the fairness issues arising as a result of the amendment of the Class B contractual rights. My learned friend, Mr. Singler, will address your lordships on the questions of valuation.
Right.
My learned friends, Mr. Thornton and Miss Peters, will address your lordships on the fairness issues from the subordinated creditors' perspective, avoiding overlap. And my learned friend, Mr. Day, will be addressing your lordships on fairness in the context of the public interest. And if time permits, he will deal with releases. So that is how we have arranged ourselves.
What's the sort of timetable for all of that?
The timetable for all of that is into tomorrow morning.
Yes.
Having said that, my lords, on the timetable, I'm given until lunchtime, and I'm very much hoping to take less time than that.
Okay.
My lords, the overview. The case of the company and the Class A is that the Class B creditors have, and I'm quoting, no rights or value to compromise under the plan to produce its restructuring surplus. However, if a creditor has rights that you need to compromise, whether that is giving up a right to payment in a distribution because they are, quotes, in the money, or it is giving up contractual rights that need to be amended to make the plan work, then they are not creditors unaffected by a plan. Their rights do not go untouched. Amendment of those rights contributes to the benefit of the restructuring. And my lords, you have to ask what rights creditors are giving up under the plan, what they get in exchange for giving up those rights, and what they would have if the plan failed. The Class B creditors give up the same rights as the Class A's under this plan. The Class A's and the Class B's get the same rights in the relevant alternative, a SAR, Special Administration Regime. However, under the plan, the Class A's get valuable additional rights that are not given to the Class B's, which are what we have described in our skeleton as the Class A rights.
But the Class B are always in the same position in the sense they're always out of the money.
My lords, I will explain to your lordships why that is not the relevant question.
Well, whether it's not a relevant question for present purposes is not the point, in the sense that the Class B creditors are, it's not suggested, for example, that if the plan were a different plan, the Class B creditors would be in the money or partially in the money or anything of that kind. What's said is, under the plan they're out of the money, and under the SAR they'd be out of the money. Is that right?
My
Factually.
lord, that is what my learned friend Mr. Singer
But is it right factually?
No, it's not correct factually. But I'm leaving that to my learned friend, Mr. Singler. I really don't want to get knocked off.
No, I think, okay.
Please. Once you've identified the rights given and the rights received in return, you then have to ask whether the additional rights that are being given is fair. And Mr. Justice Leech did not perform that exercise, in part because he was misled by the out-of-the-money mantra, which is not part of the statutory test for cross-class cramdown. Now, the plan gives the Class A creditors rights that are not given to the Class B creditors. First, they have valuable control, information and facilitation rights irrespective of whether they participate in the new money. Secondly, these rights provide them with a competitive advantage in the upcoming holistic recapitalisation. The terms or structure of the holistic recapitalisation are unknown. And in the context of that uncertainty, my lords, the formulation and negotiation of that deal is critical. Detailed information about the equity bid process, the cash flows of the group, engagement with governmental bodies at the introduction of the company, and assistance by the company with a creditor-led transaction is valuable to a class of creditor. Second, the ability to influence the liquidity position of the group, even if there can be extensions, is an added pressure that can influence matters. It may be said that those rights are insignificant, but if that is the case, why were they not given to the Class Bs in the first place, and why is there such resistance to them being given now? The reason is knowledge and access are key. And if I may borrow something that was said by the late Mr. Robin Dicker QC in Virgin Active, if you're not sitting at the table, that is because you are lunch. Now, the remainder of my submissions, that was my introductory overview. The remainder of my submissions, my lords, will break into the following four parts. First of all, I wish to take your lordships through the plan, its purpose, the amendments to contractual rights, and the rights conferred to the creditors. Second, I then want to take your lordships to the rights of the Class A and Class B creditors in the SAR regime. Third, I then want to take your lordships to the statutory provisions of 26A. And fourth, I want then to draw it together under each ground of appeal. Right. So my starting point is the purpose of the plan. And could I ask your lordships to go to the supplementary hearing bundle at tab 44, which is at page 1265, which is...
Do you know which volume that is?
Yes, my lord, I do. It's volume 3.
Thank you. Tab 44.
It's tab 44 and it's page 1265 in tab 44. Do your lordships have, I'm sorry.
Summary of the interim platform transaction, including the plan.
Correct, and I'm turning to one, which is the purpose of the plan,
Yeah.
which is the starting point.
Yeah.
The purpose and objective of the plan is to provide the Thames Water Group with a stable platform as an interim measure to facilitate the implementation of an agreed holistic recapitalisation transaction of the type contemplated by paragraph 4.7 part 1, and in order to initiate and complete the CMA redetermination if required. And we know that there has been an appeal to the CMA.
Yeah.
Then they explain what this is, how this is going to be achieved. It is going to be achieved by, first, in 121, the injection of new funding by way of super senior funding. And I'm going to show your lordships But the A's and the B's have a contractual veto right under the security that means that if their rights were not amended, that could not be fitted in at super senior level. Second, 122, the maturity dates, extending the final maturity dates on all scheduled amortisation payment dates, and they apply it to all classes.
Yeah.
I will show your lordships which debt needs to be extended during the period of this interim plan. And your lordships will not be surprised to hear me say it's 2 Class A and 2 Class B. And again, failing to extend those maturity rights means that there would be events of default.
Event of default.
Exactly.
Yeah.
And then 124, the result of the foregoing. So it is the result of that. This is the heart of it. Mitigating the risk of Thames Water having to file for special administration or administration proceedings. So that is mitigation of the risks of special administration is what this interim plan does, and that is stated to be the benefit of this plan, and that becomes important when one looks at matters later. Importantly, from the Class B perspective, and I hope I don't repeat myself here, the provision of the super senior funding requires the alteration of what are called entrenched rights. And this is accepted by the company for your lordship's notes in Mr. Fraser's first statement at paragraph 3.23, which is at bundle tab 7 at 346. He accepts that quite rightly. And the entrenched rights mean that the senior secured debt that alters B's priority cannot be issued. And of course, it also provides that payment dates cannot be amended. That's what's provided for under the contracts. As for the maturity dates, could I just ask your lordships to go to back to page 1258 of the bundle, tab 44 of the bundle, which I hope, my lords, you still have.
Yeah. 1258, yeah.
1258, my lords. I can tell your lordships that before that you get a schedule which shows all of the various Class A, Class B debt and the subordinated debt. But I just want to look at the Class B debt for present purposes. And if your lordships look down at the second debt, which has a maturity date of the 21st of March 2025, and that's a £75 million debt. And then if your lordships look 3 up from the grey line, your lordships will see 6th of August 2025, which is a £50 million debt.
Yeah.
And my lord, to be clear, if Thames failed to deal either with the entrenched rights when they introduced the supersecurity or with those maturity dates, the issuing of the supersecurity would give rise to an event of default. The failure to amend the maturity dates would result in defaults under the documents and an event of default. And that is important because it is Thames Water's case that events of default would result in the company going into something called standstill. I needn't trouble your lordships with the detail of standstill. And that would result in the company going into a special administration. So amending these rights is essential to achieve the purpose of the plan. And amending those rights contributes to the purpose of the plan and in turn the benefits derived from the plan, which is what we will deal with under ground 1A. As your lordships know, the B class creditors do not consent to the plan, and as such, the plan gives rise to forced amendments of these rights. So one then asks, in exchange for these rights, what do the B class get? And what the B class get is they are given an ability to participate in the super senior funding on a pro rata basis and limited information rights, which are similar to the rights given to the subordinated creditor. And one then asks, what is given to the A class? And there are two sets of rights that we have identified in our skeleton at paragraph 5. First, the liquidity control right, and second, the information and facilitation rights. So may I take your lordships to the liquidity control right? In the judgment and in the transaction document, as your lordships will shortly see, it is described as the June release condition, and it is addressed in the judgment, paragraphs 99 to 104. Can I take you to volume 3 of the supplemental bundle? And if I can take you to tab 47.
Tab.
47, my lord.
Yeah.
And it is page 1282 in the bundle.
Yeah.
And if your lordships, look, this is definitions, and at the bottom of the page one gets the funding conditions.
What is this extract from?
It's in the, sorry, it's in the common terms. Sorry?
Super senior finance.
Sorry, it's the super senior finance. I do apologise.
The new lender docs.
Yeah.
Yes,
Yeah.
yes, of course it is, my lord. Of course it is. I'm so sorry.
From the CCC.
I'm not working on the complete documents now, so I don't have the heading. So, my lords, if you look at the funding conditions, and then if we go over the page to 1283, and it is little Roman 8.
Yeah.
And my lords, to give your lordships the context, as your lordships are aware, the super senior funding is in two parts. There's the first 1.5 billion, and then there's the possibility of the second 1.5 billion. And little 8 provides this. In respect of any loans to be made on or after the 30th of June, including any additional loans, this is a funding condition. A supported LUA has been entered into by such date. There is then a proviso that we don't need to look at, and I then want to pick it up at such condition being the June release condition, so your lordships can see that is where the language, the descriptive language, comes from. And then there is a second proviso that your lordships will see debated in the judgment, which is provided further that where the borrower is at the relevant time acting in good faith towards a recapitalisation transaction, any extension of the June release condition can be effected with the consent of the super senior issue and the super senior security trustee in accordance with a provision that your lordships do not need to look at.
Yeah.
And your lordship should note that in paragraph 105 of the judgment, the judge noted that the company has the ability to seek an extension which cannot be refused if the parent is acting in good faith towards a recapitalisation transaction. Now, I needn't go into the details, but your lordship will see it's discussed in the judgment that there are certain sums that fall payable during the period after June out of the first tranche, and once one gets to September, one would be within the second tranche. The point for present purposes, is that it gives a certain pressure. So the second part of 8 gives the A class that do not participate. I'm sorry, I should then have shown you the supported LUA.
Supported
LUA definition, my lords, which is on 1285.
Yeah.
I do apologise. It means a lock-up agreement in respect of a recapitalisation transaction which has been entered into, and there are 2 cumulative classes. It's 2/3 of the super senior issuer funding, and then the second is the Class A debt provider, 2/3 of the Class A. And the point about that is that this gives Class A creditors who do not participate in the new money a valuable right that can be used by them in negotiations with the company. And we do respectfully submit that the right has greater value now that Thames Water is appealing the final determination to the CMA, because that appeal means that Thames is going to require additional funding to cover the period of the appeal. As your lordships will appreciate, until the CMA reference was made, one was discussing whether or not they had funding to take them to September for the holistic restructuring. There is now an appeal, and so that is going to require funding for a longer period.
Why?
Because they don't.
If they've got the funding till September.
They've got the funding until September, but a CMA appeal, and there's no evidence on this, but my understanding is that a CMA appeal would take until at least the end of the year. So there is an additional period.
Is there no possibility of RP2 until the appeal is completed?
I don't know, my lord. That's one of the uncertainties. We don't know. Can I just...
Can I just...
Yes, of course, my lord.
No. So it's just a point of detail.
Yes.
If the Class B creditors participate in the bridge, do they, in those circumstances, get the benefit of these rights? I assume they do.
They fall within the first part of this clause, and pro rata they are then part of the 2/3 for that
If they
purpose.
participate in the new funding,
Yes,
then they get these rights as a consequence.
yes, these rights, yes.
66 2/3 of the super senior.
That's, yes,
Right.
that is absolutely
So in
correct.
those circumstances, you've got no complaint on these points. It's only if you decide not to participate that
Well, my lord,
it's said that there is a disparity of treatment.
yeah, my lord, I'm not saying we have no complaint because, and I'm about to get onto it, but you have to look at non-participating. So a non-participating A-class member has got this right.
Yeah,
because
I
the same
follow
class.
that, and that's what you say is the disparity.
There is a disparity. I'm not suggesting that this is the biggest point in terms of disparity, but there's a disparity. And the Class B creditors' rights under the first part are participating pro rata in what becomes a 2/3 vote.
Yeah.
I think, my lords, you have the point. And can I just say this? For the avoidance of doubt, in the context of fairness, we do not, and in fact we did not at trial, rely on the JRC as diverting value from the Bs. It is based upon the JRC giving the A-class the ability to influence matters. So that's
And you say these any unfairness of that kind isn't going to sort of be sorted out in the wash, so to speak, when you get to RP2.
That's not the question, my lord. And one doesn't know what's going to happen in RP2. But what I'm doing is I'm analysing what creditors give up and what they get in this
Yes,
plan.
no, I follow that.
No, of course, your lordship follows.
Yeah.
Yes, and no.
But you can't approach this in a sort of blinkered way. You do have to have some regard to what this bridging finance is intended to bring about.
Yes, and we will, my lord, bear with me because it will become
Yes, I don't want to.
quite clear.
All
No, of
right.
course, but just bear with me. First of all, I'm just identifying the additional rights they get, and then
Yeah,
I will complete that exercise. I will, my lord. And your lordship will see, it doesn't come out in the wash in RP2 and one can't know. But anyway, I'll get on to that.
Yeah.
The second lot of rights I just need to take your lordships to are the information and facilitation rights. And if I can start by taking your lordships to tab 49, which I can tell my Lord Justice Zacaroli comes from the Master Definitions Agreement. And if I can start at 1298.
Yeah.
I want to look at two definitions here. The relevant creditor groups, which are the ad hoc committee and the bank group, and the relevant creditor advisors are the ad hoc committee advisors and the bank group advisors. And then if we go back to 1293, just so that we can see how this works, the ad hoc committee advisors means the professional advisors to the ad hoc committee from time to time being at the restructuring effective date. Aiken Glump, that's my learned friend Mr. Al Attar's instructing solicitors, his legal advisors, Jeffreys International's financial advisors, that was Mr. Burleson's company. But the important point for this moment is that that does not include the Class B advisors. Can I then turn to tab 50? And if I could go to 1306, and we can start to look at the rights that the various classes, the various creditors get. At 1306, we have what is called the stable platform period reports in 13. And the first point to note is 13A applies to both the Bs and the As. So during the stable platform period, TWA must supply to the security trustees. So it goes to the As and the Bs because it goes to the security trustee. And then picking it up at the bottom, a stable platform period creditor report each month on the same date as it supplies a drawdown cash flow forecast in accordance with paragraph 14, which we will look at. Then if we look at B, these are this is information provided only to the Class A's. So during the stable platform period, Thames must supply to the relevant creditor advisors, which is the definition we were just looking at. And if I can pick it up 4 lines down on the right-hand side, it is a stable platform period advisor report, again, each month on the same date. And the difference between the reports is that the Class A's get updates on cash flows and the equity process, which of course is central to the recapitalisation transaction. And so for your lordship's note, that's in Schedule 16 of the CTA, which is not in the bundle, but I don't think that that is in issue. Can I then go over the page to 1307, which is to clause 14, the drawdown cash flow. This is information given to the Class A's irrespective of whether they participate in the super senior funding, because it goes to their advisors. So you get delivered to the super senior issuer, the super senior security trustee and the relevant creditor advisors, which of course includes the non-participating, and it's a drawdown cash flow cash flow forecast. I then would like to go forward to paragraph 60, which starts at 1309. And the starting point is at 60A. Thames shall share with the relevant creditor advisors. This goes to the Class A's, irrespective of whether or not they are participating in the new money. And if I can pick it up 5 lines down, updates on key issues, including Thames' response to the final determination, the equity raise, the turnaround plan, the pension deficit, Thames liquidity, any meetings with the UK government, Ofwat and the Environment Agency and other regulatory bodies, And then further down at 2, draft term sheets or indicative terms that Thames or any other member of TWU Financing Group receive from any secured creditors from time to time. So if other secured creditors produce alternative plans, they get those term sheets. And further down, this will include, and your lordship see in 1, regular updates as to the progress of the equity raise or recapitalisation transaction, question and answer sessions over the page. 2, the provision of information as may be reasonably requested from time to time, reasonable access to Thames advisors in the respect of the equity raise, and then in C, Thames shall consult in good faith with the relevant creditor advisors and the ad hoc in respect of progress in relation to the recapitalisation transaction. And then in D, Thames shall engage with the relevant creditor groups and the ad hoc hedge counterparties on a good faith basis to facilitate development of a creditor-led recapitalisation, including access to any relevant investor data rooms, access to Thames senior management team, cooperating with the reasonable information requests of any of the relevant creditor groups, cooperating in facilitating access to Ofwat, the Environmental Agency and other relevant regulatory authorities, and ensuring that any proposal in relation to a creditor-led transaction will be able to be submitted as an offer in any formal equity process. So your lordships can see those in our submission very valuable rights in the context of what is going on during this period. And the company in paragraph 54, 50 brackets 4 of their skeleton suggests that 60D is not relevant to the Class B creditors because, quotes, it's commercially nonsensical to think that the Class B creditors could mount a credit bid. That is a bad point for 3 reasons. First of all, 60D does not refer to a credit bid. It refers to a creditor-led recapitalisation transaction. It is not limited to a credit bid. Secondly, there is nothing stopping the Class B creditors from bringing in a partner as part of any creditor-led transaction. That would still be creditor-led. And third, even if the company was right, then why give 60D to the ad hoc hedge counterparties who cannot credibly themselves prepare a credit bid given the value of their holdings? Can I then turn to 59, which is at tab 50 at 1308? Because the judge suggests in his judgment at 2421 to 2, subparagraphs 1 to 2, that given that the Bs get the rights in paragraph 59, the Class As are not obtaining any additional advantage by paragraph 60. And the company makes the same point in paragraph 51 brackets 2 of their skeleton. The right to consult and negotiate is dependent on whether there is a right to participate offered to the Bs. If I can just show your lordships. So your lordships see in 59.1, in respect of any recapitalisation transaction in which secured creditors are offered the right to reinvest, then you get into what they would get. And you can see that in Little Roman 1, it's in good faith consult with the advisors to secure creditors. In Little Roman 2, use reasonable endeavours to engage with its secured creditors and their advisors on an equal and open basis, and use reasonable endeavours to ensure the recapitalisation transaction includes options for participation. And the point is that 59A is premised on secured creditors or any of them being offered a right to reinvest by way of debt or equity or similar instrument. At that point, the group has certain obligations, but the Class B creditors might not be offered a right to reinvest, and so this right may never arise.
This is
Yes.
secured creditors or any of them are offered the right.
Yes.
Does this work on the basis that if they offer the right to this tranche of secured creditors, the rights to these benefits in 59 accrue to all secured creditors or only those to whom the right's been offered?
I would read them as only the rights to whom they were offered, but what do you think? I understand your lordship's point. Your lordship's point is that if it's offered to any, then it will include us as well. It brings me to my bull point at the end of this, because we're comparing the rights in 60 to the rights that you would get under 59. So assume, for the benefit against me, for the benefit of argument, that it's triggered by making an offer to any secured creditors that they can reinvest. One then has to compare what one is getting under 59 with 60, with clause 60, in particular, all of those provisions in 60 subsection D, which, as your lordship can see, are of a different order. And in our respectful submission, the information and facilitation rights are valuable. And during cross-examination, Mr. Cowlishaw, who is the company's expert, agreed that it is important to all stakeholders, as he put it, to have their feet under the table. It's very similar to the submission made by Mr. Dicker back when. If your lordships are interested, the cross-examination is at the transcript day 3, 21:17 to 20. And Mr. Burleson accepted that the A's will be putting their own creditor bid in, and that was transcript day 2, 85:11 to 15. And Mr. Abraham rightly makes the point, of course, that if 59 on its own was enough for all secured creditors, why would the Class A creditors have 60 in addition? Can I then move on from those rights to the rights in a SAR? Section, so my lords, you could take up authorities bundle 1, because we'll be looking at some of the statutory provisions. Section 24. Section 24 of the Water Industry Act provides that a petition for the administration of a water company may be presented by the Secretary of State or with the consent of the Secretary of State with Ofwat. Can I ask you to turn up tab 4 in bundle 1?
Yeah.
And I want to go to section 23. And I apologise, I don't have numbering on this, so I can't tell your lordships what the PDF numbering is.
No.
But if your lordships have section 23,
Yeah.
I'm grateful. Meaning in effect of a special administration order, and I show your lordships 1A, it's for the achievement of the purposes of such an order, and then go down to 2B at the bottom, where a company is in special administration as a result of an order made on the grounds that the company is or is likely to be unable to pay its debts. And then a purpose of the special administration order is to rescue the company as a going concern, and B, the transfer purpose, which is, you can see under 2A or 2AA, applies only if the special administrator thinks that it is not likely to be possible to rescue the company as a going concern.
Or it might be it'd be more efficient if there were a transfer. That's what these.
Yes,
Two.
yes.
Transfer is like to secure more effective performance.
Absolutely. But the important point, my lords, is there are two possibilities here. The company can be rescued, or the business can be transferred to another party. What it does not include is it does not include what I would describe as the quasi-liquidation type purpose that one has seen under administrations. There are no rules of distribution under this special administration. You don't have better realisation than you might have in a liquidation. These are the purposes. And it's crucial to understand this, that the business of Thames Water, one way or another, will continue. Now, if one looks down at 2DB, for the purposes of rescuing the company as a going concern, the special administrator may propose in B a compromise or arrangement under 26A.
Yeah.
So the framework that we've got is that the special administrator could oppose a compromise or arrangement in order to rescue Thames, or if he took the view that the conditions that we've looked at in sub B were satisfied, then he could transfer the business. And that is the framework that we are looking at, but the business survives. Now, looking at an administration with that work as our background, I then want to look at what an administration looks like. First point is there is no creditor control over the liquidity or cash flow. In a SAR, no creditor controls liquidity, no creditor controls the cash flow. The SAR will be managed by a special administrator who, as your lordships know, is an officer of the court, and it would be reliant on one of two sources of funding, either government funding or market funding, if private funding was available. In the Class A skeleton, it notes correctly that paragraph 99 of Schedule B1 to the Insolvency Act has been amended by Regulation 35 of the Water Regulations to make clear that grants, loans and repayments in respect of guarantees provided by the government are made expressly payable together with other contracts entered into by the special administrator. So, for example, if they entered into private finance contracts, they're expressly payable ahead of the ordinary expenses of the special administration. Funding, whether it comes from the government or the market, has priority. If I can use the language, if you like it, that we see in the plan, it has super priority. The second point that your lordship should have in mind is that secured creditors have less control in a special administration in respect of their security. If your lordships could turn up tab 2, and I should just explain to your lordships, what we have done with tab 2 is this is a conformed, if you like, version of Schedule B1 with the amendments made in it.
Yeah.
And if we could look at paragraph, if you could go to paragraph 43, which I think on the PDF is page 14, but I might be wrong.
Paragraph
43, my lord. And this is
Dealing with what?
it's the moratorium on legal processes, my lord.
Page 4, you mean? Of the
Yeah.
Internal form, my lord, absolutely.
Yeah.
This is in bundle volume 1 of the authorities.
Tab 2, page 4. Yeah.
My lord, paragraph 43, and I just want to look straight to 2. no step may be taken to enforce security over the company's property except with the consent of the administrator or with the permission of the court. A provision your lordships will be well familiar with, and your lordships will be well familiar with the law on that, looking at Atlantic, Paramount and all of those cases. The second point, sorry, Mark.
Sorry, this is a specific schedule, new schedule to the Insolvency Act dealing with the water industry.
What we've done is Schedule B1 has been amended,
Yeah, okay.
and this is conformed. So we've
Oh, I see, it's conforming. Okay, I've
we've
got
put
you.
the amendments in to make it
got you.
easier for your lordships
Okay.
to see.
Very helpful, thank you.
Thank you,
Have you
Mark.
identified where there are amendments?
Yes, we have actually, and I think we've done that in which tab is it?
Oh, don't worry. I just
I mean,
this
he's
document-
actually-
Oh, yes, I'm so sorry, yes.
If you look at the footnotes,
If you look at the
it's quite apparent.
footnotes, my lord,
So if we're
identify
looking at
the
five
amendments.
A, sorry, it's at five A, for example, on page 4.
Yep.
B, with the permission of the court, was introduced by the
Yes.
Water Industry Special Administration Regulation 2024.
Absolutely, and my lord, I'm about to show you one that has been amended, so I can
Yeah, okay.
I can do this. If we could go forward then to paragraph 71.
Yeah.
Paragraph 71, 1, this is the court's power, as is the power of the court on an application of the administrator to dispose of property subject to a security.
Yes.
So the court may by order enable the administrator of a company to dispose of property which is subject to a security, as if it were not subject to the security. That is common, it has not been amended. What has been amended is in, if we look at 3, which is the condition of an order. An order under this paragraph is subject to the condition that there be applied toward discharging the sums secured by the security, and it's the net proceeds of the disposal, and then this which has changed, which is any additional money required to be added to the net proceeds so as to produce the amount determined by the court as the net value which would be realised on a sale of the property at appropriate value. And your lordship see the footnote to appropriate value, which shows your lordships where that was introduced. And my lords, if I could take you forward to its internal page 30, the definition of appropriate value, which is in paragraph 111, and it is
The best price could reasonably vary on sale consistent with achieving the purpose of special administration.
precisely.
Unsurprising.
Unsurprising, but important, because the ordinary definition, which if your lordships want to look at, is in tab 3, under 3B, is in a normal administration. Well, perhaps I'll just show it to your lordships.
Yeah.
In tab 3, when one looks at 71(3), if your lordships have that, 71(3)B, is the amount
Market value,
market value.
which is then defined at slightly further on.
Yeah.
Sale of property in the open market by willing.
Yeah, my lords, your lordships have the point. But this is important because in a special administration, the secured creditors, number one, they can't enforce their security. And number two, the special administrator has always got the ability to sell the secured assets. So, for example, if he is effecting a transfer, he can sell those assets, and the price is a different price. It is the appropriate value, which your lordships can see is defined by achieving that process. It is not the market value. Now, whether that's more or less doesn't matter. The point is that none of the secured creditors, and in particular the Class A creditors in conversations with the special administrator, have got a veto. They don't have the veto right that they have under the contracts. And so that conversation would be different. Sorry, my lord.
Yes, I'm just trying to, I mean, this provision is dealing with, you're right, I mean, there can be an enforced sale subject to report of the secured property. So this presumably takes it out of the hands of the secured creditors as to when to realise their security. But it doesn't alter the destination of the proceeds of sale, does it?
It doesn't, but it does change the test. So that what the special administrator is saying, in order to achieve this transfer purpose, I am going to go to court, or I can go to court, and get an order. And therefore, when you are talking to me about the holistic plan that I am putting together, because that's my first purpose, to achieve the rescue, that's what I'm trying to do. Don't just say to me, I'm sorry, I have got a veto right, therefore if I don't like what you're giving to me, tough. What the special administrator has got is it's a change, if you like, of the negotiating position of the parties, and that has been introduced by Parliament, and one understands why in the context of a water company, because you've got to have one of two things. You've either got to have the rescue or you've got to have a transfer. And what you can't do is you cannot have secured creditors standing on their secured rights in such a way that makes the achievement of those purposes difficult. So what Parliament has provided is that the administrator can come along to the court and say, in order to achieve the purposes for which I've been appointed, I need you to make an order under 1771 for me. And yes, my lord, you're right. The proceeds of sale would go to them, but in addition, if you like, the economic risk to the administrator is the appropriate value. It's not the market value, and that's a change. And in my respectful submission, it's a change we should be aware of when we are considering these respective rights.
Can you just unpack what you call the veto right? Remind me what you mean by that exactly in this circumstance.
What I mean by that is that they have got rights under their security, under their security, and those rights are going to, one assumes, in a holistic restructuring, they are going to agree, unless they're crammed down, of course, they would have to agree to whatever amendments are made in the context of the recapitalisation transaction to their secured rights. At the moment, they have got rights under the WBS. They have got a series of debts. Those debts are secured under the WBS. They have rights of enforcement.
Yeah, so that you're not talking about any particular veto right granted by
No, I was using a shorthand, my lord, and I wasn't intending to say, look, there is a veto right. I'm sorry if I wasn't being clear, but the point I was making was there's a difference between a negotiation with creditors in that position and creditors negotiating with a special administrator who can say, well, look, ultimately, if I need to, I can go down this route, and it makes a difference to the discussions. Of course, the context of all of this is a plan that takes you to.
I mean,
I'm sorry.
What is the security? I'm not asking you to give me this, but I mean, presumably this must, I envisage, going to be security over the assets of the company. I don't know. What are the water pipes or something?
Well, my lord, it's what's called a WBS. It's a whole business security, and my lord, you're absolutely right. Can we just conceptually say it's security over everything? But there are specific types of asset which require special treatment, and I don't think I need your
and
lordship.
they're presumably assets that obviously the company or whoever runs the business will need to continue to hold in order to operate.
Absolutely.
and in the event of a transfer would be needed to be vested in the new company free of the pre-existing security.
Yeah, it would have to be exactly, my lord, free of the pre-existing security, but to be absolutely clear, although I'm not trying to restructure Thames Water on my feet, to be absolutely clear, in order, just suppose that it was decided to transfer out, in order to do that, in order to pay for assets currently subject to the security, one assumes that any purchaser would themselves need to put in secured financing of some sort. So one can assume that they take over the assets, but then they would securitise them. But that's me on my feet trying to come up with a structure for the restructuring of Thames Water. The important point, my lord, is my Lord Justice Patten's point, which is, yes, they have got the ability to sell these assets to a business to whom they are transferred, free of the security. Yeah, I'm reminded that I'm going too slowly, which is disappointing. Can I briefly then move on to the limited information with all creditors being in the same position?
Yeah.
And I'll do this without turning up the provisions. I'll just tell you what they are. The first thing is paragraph 49(1) of Schedule B1, all creditors are sent copies of the statement of the Special Administrator's proposals, and under paragraph 54 they get substantial revisions. Under Rule 18.6, which is in the Authorities Bundle 11-175, all creditors have the right to receive reports detailing the progress of the administration every 6 months. And my lords, Rule 1239, there is a right to inspect the court file. In 1240, you've got the right to take copies of documents that you expect. The point is a simple one, is those are not extensive information rights, and both the Class A creditors and the Class B creditors have the same rights in a special administration. May I then turn on to
that limited information.
that limited information?
That if the special administrators wanted to give a particular interested party more information, they wouldn't be obliged to give it to everybody else at the same time.
No, unless they were acting in a manner unfairly prejudiced, one assumes. But yes. So can I then go to Part 26A and the statute, if I may?
Yeah.
Starting with the statute. 901A.
Which is where?
Which is in tab 7, my lords. So for this part of my submissions, I'll be taking your lordship through the provisions which are in tab 7.
Yeah.
And so one sees 901A, condition A, the company's encountered financial difficulties. Condition B, and in 3B, the purpose of the compromise or arrangement is to eliminate, reduce or prevent or mitigate the effect of any of the financial difficulties mentioned in subsection 2. And then if I can go forward to 901C, which is, I don't have page numbers, there's a couple of pages forward. 901C, the holding of the meeting. Court order for holding a meeting. The court may, on an application under this section, order a meeting of creditors, class creditors or members of the company, and then it identifies who can make it, and then the important subparagraphs are 3 and 4. 3 is every creditor or member of the company whose rights are affected by the compromise or arrangement must be permitted to participate in a meeting ordered to be summoned under subsection 1. And then 4. Subsection 3 does not apply in relation to a class of creditors or members of the company if, on an application under this subsection, the court is satisfied that none of the members of that class has a genuine economic interest in the company. Section 901C4 uses the phrase genuine economic interest, which can be found in case law relating to the scheme jurisdiction, which we will come to in due course. This is a very powerful provision because it means that parties' rights will be altered or extinguished without their ability to vote. This was not the case under Part 26, where such creditors were simply left out of the plan and maintained their existing rights. 2 points on construction. Number one, it is one of 2 subsections that uses the phrase genuine economic interest. 2, it does not prescribe the circumstance in which none of the creditors should have a genuine economic interest. Can I then look at 901F? 901F identifies the discretion to sanction a plan. And your lordships will see that if a number representing 75% in value of the creditor or class of creditors present and voting agree a compromise, the court may, on an application under this section, sanction the compromise or arrangement. And 2, subsection 1 is subject to 901G. If we can turn to 901G, which is, I hope, over the page. This is sanction for a compromise or arrangement where one or more classes dissent. And it explains that the section applies if the compromise arrangement is not agreed by 75% in value of members of the company present and voting. And then in 2, if conditions A and B are met, the fact that the dissenting class has not agreed to the compromise or arrangement does not prevent the court. So it's a prevention. It's not automatic. Sorry. Yeah. Condition A. Condition A is the condition that applies to the dissenting class. And it is, the court is satisfied that if the compromise or arrangement were to be sanctioned under 901F, none of the members of the dissenting class would be any worse off than they would be in the event of the relevant alternative. 2 points. The test is any worse off. It is not no genuine economic interest. And second, the test requires us to ask if they are any worse off in the relevant alternative. Condition B is in subsection 5, which is the condition that applies to the assenting class. And what your lordships will see is that the compromise arrangement has been agreed by a number, by 75% in value of members present and voting and so on, who would, and there are then 2 conditions. 1, receive a payment, or 2, have a genuine economic interest in the company in the event of the relevant alternative. So 3 points. First, there are 2 conditions that may be satisfied. The first is the receipt of payment. The second is that they have a genuine economic interest. As a matter of construction, a genuine economic interest must be to the receipt of a payment. Second point, the assenting class can have a genuine economic interest And that tells us that the test for the dissenting class is not that they have no genuine economic interest. The dissenting class must be no worse off, which is different language. And the third point is that the dissenting class must either receive payment or have a genuine economic interest in the relevant alternative. And your lordships have already seen under 901C, which is the other subsection that uses no genuine economic interest, that does not refer to a circumstance. If it is a so if the relevant alternative is a distributive process, then the focus is going to be on a right to payment. Where other rights are concerned, no genuine economic interest must mean more than a right to payment. So can I now deal with the phrase, which we call the mantra, out of the money? 4 points to note. First, the phrase out of the money does not appear in the statute, either in 901C or 901G. The company's skeleton habitually uses the phrase out of the money. If I could take your lordships to tab 13 of this bundle and ask you to turn to page 34 of the explanatory notes. Paragraph 188, so it's internal page 34. And this is the only place in which the phrase out of the money appears.
188.
188. And if I can just show your lordships, 188. 188 says section 901C sets out who may apply to the court for an order to summon a meeting. The section provides that as a default, creditors and members whose rights would be affected must be permitted to participate in a meeting ordered by the court. However, if the court is satisfied that a class of creditors has no genuine economic interest in the company and then it's an out of the money class, the court may order for that class of creditors or members to be excluded from the meeting summoned in subsection 1. An application to exclude an out of the class creditors or members must be made by the original applicant under subsection 1. There is, the first obvious point is, I'm sorry my lord, did you?
No.
The first point is that that is solely with reference to 901C.
Yeah.
It does not mention the relevant alternative, as 901C doesn't. And there is no definition anywhere of what is meant by that phrase or how it is determined. The second general point we make is that 901C4 is a gating provision. If an order is obtained under 901C4, there will be no dissenting class of creditor with no genuine economic interest in the company, because no such class will vote upon the plan. So the cramdown provision in 901G is not engaged. The third point is that in contrast, 901G is relevant when a class has voted on the plan and dissents. And within this context, condition A does not refer to economic interest or the absence of economic interest. It refers to no worse off. And the second thing is Parliament has chosen to use the words in the relevant alternative in 901G5 for the purposes of condition B to determine whether or not the crammed down jurisdiction is engaged. The same phrase is not used in 901C4. And that is a clear indication that the legislature intends the test to be different in relation to each section. And the fourth point is that the different test also makes sense, given the purpose of the two provisions. In 901G5, it makes sense that the genuine economic interest is by reference to the relevant alternative, because that would apply a tougher test on the assenting class. The relevant alternative will be the lower value. So the assenting class has to show a genuine economic interest in the lower value scenario. And this is important given that the cramdown is an extraordinary power which overrides the rights of the non-consenting creditors. Conversely, 901C4, the test gives the creditor class that is going to be disenfranchised the benefit of a valuation that focuses on the intrinsic value of the company. It does not focus on the relevant alternative. So under 901C4, the question is, does the creditor have a genuine economic interest? And so I turn to...
Your submission is that's not limited to in the relevant alternative.
Exactly right.
That's where you're going.
No, exactly right. And what I want to do now, and I hope not at too much length, but I want to turn to what do we mean by genuine economic interest.
Your clients weren't prevented from voting, were they?
No application was made. And in fact, in my submission, that would have been misconceived, because we have got a genuine economic interest by reason of the fact that we have got those contractual rights that I identified at the start, which need to be amended. And those contractual rights have an economic interest. I see your judicial eyebrow move.
That would always be the case, wouldn't it?
No, it wouldn't. It would always be the case if you're looking at, because you're looking at genuine economic interest in the context of what you're doing in the plan. And that's one of the reasons why, whether it's a payment, whether it's distributive, you're looking at payments, which is where out of the money comes in. But anyway, look, and you're looking at what you need to do in order to make this, extend this platform through to September. In order to extend this platform through to September, you don't need to amend everybody's contractual rights. You need to amend the rights that matter. And when you ask yourself, what are the rights that matter that I have to amend, and then say, well, that gives you a genuine economic interest. It's an interest under the contracts in relation to what I'm doing to extend this platform. So in my submission, if they'd made that application, it wouldn't have worked. Sorry, what have I done? Okay, well, we'll come to fallback.
Well, are you going to show us a genuine economic interest?
Yes, I want to move on to genuine economic interest. And I want to start by talking to your lordships about the scheme authorities. And I'm not going to turn them all up.
No.
The scheme authorities show, first, it is not necessary for a company to consult any class of creditors who are not affected by the scheme, either because their rights are untouched or because they have no economic interest in the company. And the test is whether they have a real, as opposed to theoretical or purely fanciful economic interest. And your lordships may take the view that the use of genuine is a reflection of the use of real, which we'll see in the cases. The basis on which the court applies this test varies. It will depend, for example, whether the company is a going concern, for example, Bluebrook, or whether it's in an insolvency process, for example, T Corporation. And we deal with the relevant cases in paragraph 37 of our skeleton. So by way of overview, T Corporation, the company was in liquidation. Under the legislation in force in 1904, when T Corporation was in liquidation, it was only possible to make a distribution through a scheme of arrangement. The question was whether the ordinary shareholders would be entitled to value in the liquidation. That was the context. In British and Commonwealth, the company was in administration, and it could only make a distribution through a scheme, because as your lordships will no doubt know, it wasn't until 2002 that you could distribute in an administration. So they needed to use a scheme, and the question was whether the Coles were in the money. And on the facts, there was 400 million to distribute, and the more senior creditors swamped that 400 million. It wouldn't mean that the Coles rights were destroyed or went away or anything of that sort, of course, because if subsequently more value had come into the British and Commonwealth administration, their rights were still there. In Maxwell, the company was in administration again, and the question that arose in the context of the scheme of arrangement was whether the bondholders were subordinated creditors, which, as your lordships will recall, was a question of some uncertainty back in the day. If they were subordinated, they were out of the money on the facts. In each of these cases, the company was in an insolvency process, and the only right of the relevant creditors was to a payment or a distribution within those processes. The question was whether, as a matter of fact, the creditor or shareholder would receive a payment or a distribution. The creditor's economic interests were tied to whether the assets were sufficient, if sold, to make a payment to the excluded class. And that's where the concept of in and out of the money came from. That brings us to the two modern cases, which are My Travel and Bluebrook, and it's suggested that it might be a convenient moment for the transcript writer.
5 minutes, please. Thank you, Will.
Court rise.
How are we doing? The authorities, but neither do I. Neither do I. It's all the authorities' matters.
Sorry, I can help you out.
Sorry, I
I'll help you
can't
out.
help.
Sorry. What's happening?
Yes, darling. It's going well. It's going. Good. You should smile. Okay, let's get Bluebrook. Total respondent to 45. Am I making any fuck ups? Tony's on it. Tony's. Sorry, I've got the point. I don't need to go.
Yeah, look, so we'll go back to the
Yes, my lords. My travel is the first and only authority in this line of authorities that determines economic interest by reference to the scenario where the scheme has failed. In Bluebrook, Mr. Justice Mann rode back from his position in my travel, determining the economic interest by reference to a going concern valuation. Before I turn it up, can I just give your lordships the main facts? The assets of a corporate group were to be transferred to a new group, leaving some liabilities behind. The existing group's senior lenders were to acquire most of the equity in the new group. The liabilities left behind included debts to mezzanine lenders, and the only right that the mezzanine lenders had was a subordinated right to payment. They were excluded from the scheme, And this was because the value of the group's assets was less than the value of the senior debt, which was compromised by the schemes.
Yeah.
And the mezzanine lenders opposed sanction on the basis that the schemes were unfair to them. The transfer of the assets was to be effected by a pre-pack under the control of the administrator. Can I ask your lordships to turn up the authority, which is in 45 of bundle 2 of the authorities bundle, tab 45, and I just wanted to go to a couple of paragraphs. Paragraph 13, which is on, I used the proper pages, 345 at the top, just below letter A, and your lordships see they produced a report to analyse the value of the group for the insolvency practitioner in waiting, say the person who it was intended to be the administrator in the pre-packed administration that would intervene, and then down above C, the report valued the group on a going
Sorry,
concern.
which page are we on?
I'm so sorry, my lord. 345, internal 345, which is, if your lordship's looking at the PDF, I believe it's 216.
216.
No, that's the PDF, my lord, not the paper version. So we're in tab 45,
Yes.
and using the numbers old style of the authority. Top,
Which paragraph is it?
The report.
paragraph 13 of the report. Much
Paragraph
easier, my lord.
13.
I think from now on we'll do that.
Yep, okay, got it.
And I just wanted to pick it up. I've got it above letter C, but your lordships may not have that. It's clear that the report valued the group on a going concern basis and not on a liquidation or even a fire sale basis.
I haven't got that.
Does your lordship have paragraph 13?
Do.
1, 2. It's
That's
letter F, I'm
letter
told.
F.
Letter F. I'm so sorry.
Clear the report value of the group on a going concern basis.
And then they identify 3 different bases on which the valuations have been done, which we're not concerned about. I then want to go to paragraph 25, which picks up a point I've already made, in which it says, in promoting and entering into a scheme, it's not necessary for the company to consult any class of creditors who are not affected, either because A, their rights are untouched, or B, because they have no economic interest in the company. And he then goes through T Corp and my travel, and I just wanted to pick it up. Does your lordships have a paragraph that starts if there is a dispute,
Yes.
which is just below C, I'm told? If there's a dispute about this, then the court is entitled to ascertain whether a purported class actually has an economic interest in a real as opposed to a theoretical or merely fanciful sense, and act accordingly. Where things have to be proved, the normal civil standard applies. The same case indicates the mere fact, the possibility of establishing a negotiating provision, extracting a benefit from a deal is not the same as having a real economic interest. The basis on which assessment of that interest is carried out will vary from case to case. So it's real as opposed to theoretical or merely fanciful. And then paragraph...
So do you stand by the last sentence?
The last sentence, it will vary from case to case.
No, sorry, last sentence. The fact that having a negotiating position, being able to extract a benefit, is not a genuine economic interest.
Yes. No.
You agree with that?
That's not what this is about.
So merely having a right, which needs to be compromised, is not enough to have a genuine.
No, that's not what I was saying, because one needs to see what the economic value of the rights is, and one needs to remember that there is a difference between payment and genuine economic interest. We've got to establish what that is. So that was 25. If I can then flip forward to 36. The point that your lordships will get from 36 is that the alternative in that case was, the alternative schemes was an insolvency process, And then going forward to 40, if I can pick it up, do your lordship see, after he says the point has therefore been rendered academic, further rendered academic by the fact none of the valuations produced for the scheme companies is in fact a liquidation valuation in the sense of a breakup valuation. So there is a difference, as your lordships know, between going concern valuation, breakup valuation, and these were going concern valuations. And flip forward to 49.
Yeah.
And I want to pick it up 4 lines down. The most that it does in the present case is to give pause for thought on this point. Are the purchasers in fact getting too good a deal, too much unfair value? Because in the present market, sales are unlikely to take place. And when economic conditions change, the same group will be perceived to be more valuable, and the purchasers will ultimately reap the benefit of that. This is not quite the way the case is put, but I can see that in some circumstances it might be. It is, I suppose, another analysis of intrinsic value which is said to differ from current market value. And then in going forward to F, and it's a few lines down, I've got it under little f, but I don't know if you have, where it says it does not, in my view, demonstrate with sufficient clarity market conditions are currently giving the senior lenders an unfairly good deal. So your lordship see that the question that he asks is whether or not the senior creditors are getting an unfairly good deal. And then going on to 51, where he talks of a realistic chance of there being greater value. And over the page on 52, which I've got just below letter B, and it's the 8 lines from the bottom, I do not consider that it is successful in displacing the company's evidence, and indeed in some respects not seek to do so, it seeks to do something different, raising a sufficient possibility of there being some unrealisable value in the group, which the senior lenders will be the unfair beneficiaries of which, if the restructuring goes ahead. And so what your lordships get from that is that when you are determining whether a creditor has a genuine economic interest in a company, outside a case where the company is already in an insolvency process, the focus is on a going concern valuation, not a valuation where the scheme or the plan has failed. Can I then move on to out of the money and cram down? I want to make 3 observations in relation to part 26A. First, the test which applies to determine a genuine economic interest under 901C4 is real as opposed to theoretical or merely fanciful economic interest. That is a stringent test for the proposer to satisfy. In most of the cases in which that test was satisfied, the company was in an insolvency process. Yeah. And the effect of an order under 901C4 is to disenfranchise the class and forcibly then compromise their rights.
Can I be clear?
Yes.
Are you criticising Mr. Justice Mann's interpretation of what having no economic interest means? Because in paragraph 25, I think he takes the view, as he says, that it means that you aren't going to get anything out of the company. Financially, exactly.
Yeah. It's looking at the future financial advantage that the relevant class might obtain, and whether or not it's been deprived of it. So it's all focusing on, as you might expect, given the use of the word economic, financial interest. True it is, you're absolutely right, that when it talks about payment, it means payment, immediate payment, but genuine economic interest is looking at the financial advantages that might accrue in the future.
Well, it's looking at the financial advantages which the relevant creditor
Yeah, it's
has
not
got.
looking at other things than money.
Well,
really,
it's,
or
well, we'll come on
money's
to
worth.
what that means. It means the incidental rights to the provisions that you're looking at.
But does having no economic interest mean out of the money?
No.
It doesn't mean that.
No, it means that if you are looking at a liquidation case in which the only thing that can happen is you're going to get a distribution. But we need to look at it in a...
So the explanatory note's wrong.
No, my lord, that is looking... No, I'm sorry. We're falling into the trap of compressing, and we must deconstruct these different rights. 901C4 is concerned only with genuine economic interest at the moment. 901G5, when it talks about genuine economic interest, is looking at the relevant alternative. That is different. And it takes away from my lord's point, because you're not looking at any future potential rights, it identifies the circumstance. And the condition that applies to dissenting creditors is no worse off in the relevant alternative. So, my lords, one can't fall into the trap of thinking that one has got a general ability to say, oh, there's no genuine economic interest sometime in the future. That's not what you're looking at. In the case of the assenting creditors, they have to have a genuine economic interest in the relevant alternative, which is identified and specified. And in the case of the dissenting creditors, it is no worse off in the relevant alternative. It's really important. One can't...
What I'm trying to get clear is the scheme under the Act, you can disenfranchise a class of creditors if they have no genuine economic interest in the company. I know it didn't happen yet, but I just want to be clear what you're saying is the test that you apply in deciding whether or not you can disenfranchise somebody. Because you're not there talking about whether they're worse off under the scheme or anything.
No.
It's a prior issue, namely whether or not they need to become involved in that process at all.
Yeah, and it is no genuine economic interest in the company as a going concern as it is now.
Yeah.
It is not if it goes into liquidation, it's not in the relevant alternative, it's not if the plan fails. And that's really what one gets out of Bluebrook. But one sees it through all the cases. So your lordship is absolutely right. It is a much more stringent test. The ability to exclude a creditor of the company from even being able to vote is a much more stringent test. And one of the mistakes that one can see flowing through the cases is unfortunately, it has been put to judges, and judges have picked this up in some circumstances. It's been elided across. Huge mistake. And we need to... So while we're talking about 901C4, we are only talking about a genuine economic interest. And that means at the moment, as a going concern, and one's seen how that's dealt with. Do not then say, because of that, when I get to the cramdown question, I'm simply applying the same test, which is one of the problems with Mr. Justice Snowden in Virgin Active. But we'll come on to that.
But whether it's looking at the present or, as it were, prospectively, a genuine economic interest must mean the same thing. Can't mean different things, can it? It must mean the same thing.
It means the same
Otherwise
thing.
they'd use yet another phrase. I mean, it's not exactly
No,
the
no, no.
world's best drafted legislation anyway, for all sorts of reasons. But, you know, let's face it, they would have used a different phrase.
No. I quite take that point, but it's the same phrase used in different circumstances. That's the point that one must get hold of. Because what your lordship's put to me is, well, can it be an economic interest in some future circumstance?
Well,
And-
it's
and-
not, maybe in a future circumstance, but probably not the right way of putting it. But in the relevant alternative,
My lord, I'm going to take a pass on this and just tell your lordships that my learned friend Mr. Singler is going to deal with why we have a financial interest in a going concern. So I don't want to take his thunder. I don't want to mess up what he's going to submit.
I don't want to take this, but I mean, surely if you look at it on the first at the first stage, at the C stage, as to the position now, you're simply, I don't know, conducting a sort of balance sheet exercise, but you're saying, are the debts of the company such that you have no entitlement, no economic interest in any of the, if you like, the equity of the company, such as it may be. In other words, the value of the company is simply insufficient to give you any return at that point.
And that, my lord, is, I would respectfully
And you could be excluded on that basis
yeah, but that,
from the scheme meetings.
yeah, you're excluded from the meeting.
and that is why they ask the question, do you have a real as opposed to a theoretical or fanciful economic interest? So if your economic interest is not theoretical or merely fanciful, you go to the meeting and you can vote. And that's the test, and that's why it's there. Now, the liquidation cases,
Well, that's right, you see.
well, that was Mr. Justice Mann's decision, and we respectfully think that that is right. But the important point, my lord, is that in the liquidation cases, you had clear evidence of what the economic interest was. And so when you go to a case like Bluebrook and you're looking at a going concern question, you don't have that. So you have to ask yourself, is this real? Or is it merely theoretical, merely fanciful, theoretical and fanciful? That's what the cases say. And that makes sense because you shouldn't be allowed to vote if there is something theoretical and fanciful. One can understand that because on the balance of probabilities, you're not getting there. But if it's real, then you should be able to vote. And that is a much more stringent test than what we're coming on to.
Can I just,
Sorry.
I'm not quite sure where we are on this point. I understand Mr. Singler is going to take us to the actual valuation
Yeah, he's going to deal with
issue.
that.
But the point I think you're making at the moment is just that you don't merely look at what would happen in a distributing insolvency now. You look at real value in terms of going concern.
Yeah.
But even assuming on that basis that you're out of the money, because even giving the company its valuation on a going concern basis, your debt would not be repaid if there was to be any chance of repayment. You say, I think, that you still have an genuine economic interest if what you have is a right which needs to be dealt with within a plan or scheme.
My lord, that would be the question, but the question...
Is that right? Are you still, so it's the point...
Yeah, but my lord, if you've got a right in a distribution, you clearly have a genuine economic interest. You have a real economic interest. The question that would be dealt with on assuming that you haven't got such a distributive right would then be, can I persuade the court, or can the court be persuaded, because it's the applicant, can the court be persuaded that that right is not enough to give you a real economic interest? And I'm not saying in no circumstances can it. None of these are binary in that sense. One has to ask, why is that a genuine economic interest? And if your lordship was to take the view that that was merely fanciful because there wasn't enough behind that right, then you could be excluded. But if the court was persuaded, as Mr. Singler will persuade your lordship shortly, that there is a genuine economic value behind the rights that you've got, then it won't. And I hope that that makes that clear.
Well, I think my question is assuming that on the best valuation evidence, you are out of the money. Let's just take that as given. So however highly Mr. Singler can put the point, you're out of the money, right? There's no chance of being repaid by this company because of its lack of value in the assets. In those circumstances, do you accept that a fortiori you have no genuine economic interest, or do you say you still have a genuine economic interest if you have a right to be paid in law, even though there's no money to pay you?
No, that would be fanciful. I understand the point your lordship's making, and that would be fanciful. That wouldn't be real. And I understand that. So
That's clear.
I'm sorry if I wasn't clear enough. My apologies. Right, sorry. Going back to the note. I wonder if we've done... Sorry? Yeah. I'll go on to my second proposition under 901 C4. The proposer of a plan in our submission cannot take the benefit of 901 C4 without having applied under that provision. So the whole point is to disenfranchise a class with no genuine economic interest. And if you are excluded, then there's no question of cramdown. And in our submission, Virgin Active is wrong to suggest that you can, by analogy, apply 901 C4 within the different context of a cramdown. So to put it this way, it does not follow that because under the old scheme cases, it was fair to exclude a creditor, ergo it is fair to cram them down under 901G4. That is a non sequitur. Third point, and alternatively, if the court can take into account the effect of 901C4 at the discretionary stage to cram down a dissenting class, it should apply the same test. In other words, real as opposed to theoretical or purely fanciful. There is no precedent in the scheme cases for a process where a party can be denied a voice and have their rights forcibly compromised. And if the court is going to consider that within the exercise of its discretion, it must apply, in our submission, the right and stringent test that we saw under the old scheme cases. What the court cannot do, which is what Ms. Justice Snowden did in Virgin Active, and it's at least what the learned judge in this case interpreted Ms. Justice Snowden doing Virgin Active, is to deny the Class B creditors a voice based on a finding of value within the context of a different worse off test. So against that background, can I just show your lordships briefly Virgin Active, which is in volume 4 of the authorities. And your lordships have got it at tab 83.
Volume 3, Mark.
Sorry, I was at volume 3. I've got volume 4. Tab 83.
Yeah.
I think it's volume 4.
Thank you, William.
Virgin Active.
Yeah, this is Virgin Active, and if I can take your lordships, I'm not going to take your lordships through the whole case, I'm just going to dip into the relevant parts. 238. So if your lordships have 238, can I use the page ref numbers at the top right hand? In other words, 117. But anyway, your lordships have paragraph 238.
Yeah.
So your lordships see that Ms. Justice Snowden refers via Mr. Justice Trower in Deep Ocean to the scheme cases that we've identified, and then moving swiftly on to 242, he summarises the principle that he says can be derived from the scheme cases. And perhaps, my lords, if you could just cast your eyes, just remind yourselves of 242. He summarises those principles.
Yeah.
And then if we go to 247, he goes on to consider whether 26A signalled a departure from those cases. So we go to 247, where he says, against that background, there's nothing in the provisions finally enacted 26A or the explanatory notes that indicates the legislature intended any different approach to be adopted by the court to the position of creditors who are out of the money under the relevant alternative. So your lordship see the immediately bringing the relevant alternative into play. Quite the reverse, the provisions of 26A build upon that approach. Although 901c3 provides that every creditor whose rights are affected by a plan must be permitted to participate in a class meeting, 901c4 provides this does not apply to a class of creditors if the court is satisfied that no member of that class has a genuine economic interest in the company. It is, I consider, tolerably clear that this test of a genuine economic interest reflects the observation of Mr. Justice Manley Bluebrook that what the court must ascertain is whether a purported class actually has an economic interest in a real as opposed to a theoretical or merely fanciful sense. We do not cavil with anything up to then. And then he says this, and that it is to be applied to the plan company by reference to the relevant alternative for the company if the plan is not sanctioned. Now, your lordships have seen what Mr. Justice Snowden's done at that point in the context of the cramdown is he has, in the context of 901C, he has said that that is to be applied to the plan company by reference to the relevant alternative. And your lordships have seen there is no reference to the relevant alternative anywhere in 901C, and nor was that the test in any of the scheme cases apart from in my travel. And then if we can go on to 248, where Mr. Justice Snowden goes on to say that conclusion is to my mind put beyond doubt in paragraph 188 of the explanatory notes that explains that as a default under 901c3, all creditors whose rights are affected by the compromise arrangement must be permitted to participate, but then states, and he then quotes from paragraph 118, and that is correct, but that's in the context of 901c, and he then says the express equation of creditors with no genuine economic interest in the company with an out-of-the-money class is striking. The logic of this point is if creditors who would be out of the money in the relevant alternative could be bound to a plan which affects compromise or arrangement, the class without even being given the opportunity to vote at the class meeting, the fact that they have participated in a meeting which votes against the plan should not weigh heavily or at all in the decision of the court as to whether the exercise of the power to sanction the plan and cram them down, nor is it easy to see on what basis they could complain the plan was unfair. So that is the paragraph that Mr. Justice Leech relies upon. And 2 points at this stage.
Along with a lot of other judges. Sorry, my lord? Along with a lot of other judges, including Mr. Justice Trower.
Yes, my lord. That is why I call it the out of the money mantra. Creditors out of the money in the relevant alternative is not what is said in the explanatory note. It's not the test in 901c4, and it's not the test in Bluebrook. He then applied that test to fairness in the context of a cramdown, and I will explain why that's incorrect when I come to ground 1B. Before I go on to that, and I ask your lordships to bear with me on the structure because it matters. Before I do that, I then want to turn to the 3 grounds that we've got, and I want to start with 1A. So what I've done so far, and you might throw your hands up in horror, it's just the context structure. Ground 1A is what I would describe as the no restructuring surplus. At paragraph 249 of the judgment, the judge held that no issue of horizontal fairness of the kind that arose in Adler arose in this case. And one of the reasons that he gave for that conclusion was that the plan is an interim plan and involves no restructuring surplus. In our submission, that was an error. The plan provides a stable platform which facilitates a recapitalisation through RP2 outside a SAR. This mitigates the financial difficulties of the company, which the statute requires. The statute requires mitigation under 901A. The stable platform is the restructuring surplus or the benefit of the restructuring. And the plan provides the surplus or benefit in two overlapping senses. First of all, the plan provides the company with the opportunity and associated advantages of pursuing an equity raise and RP2 outside of an insolvency process and gives creditors the prospect of a better recovery, a better outcome, sorry. Second, even if one looks at the issue of surplus purely in terms of financial value, the judge found that there was more than a fanciful prospect that RP2 would succeed, and so this plan will facilitate the distribution of greater value under RP2 than a SAR. Remarkably, at paragraph 41 of its skeleton, the company says that although the plan facilitates RP2, it generates no benefits over and above the SAR. That is in paragraph 41 of its skeleton. If that is right, the company should go into a SAR. You're left asking, if that is right, how does the plan mitigate the company's financial difficulties? Now, developing our submissions, the logical starting point is the restructuring surplus as a concept or term, as the language has a tendency to confuse. And if I could start with Adler, which is in tab 118 of volume 6 of the authorities. And I just wanted to turn up paragraph 160. Yeah. And which is, I've got it at 785 of the report, and I wanted to turn just under
785.
785, yes, my lord. Thank you. So I wanted to look at the end of 160, and I wanted to start at, let's see, it says, in my judgment, that exercise of judicial discretion to alter the rights of a dissenting class for the perceived benefit of the assenting class necessarily requires the court to inquire how the value sought to be preserved or generated by the restructuring plan over and above the relevant alternative is to be allocated between those different creditor groups. So that is the question, and we respectfully agree. What? Preserved. Did I not say preserved? 161. It is this concept that has been encapsulated by the expression the fair distribution of the benefits of the restructuring or fair distribution of the restructuring surplus, and he refers to depotion and my learned Lord Justice Zacaroli's decision in Houst or Hoost to similar effect. In her paper, Professor Sarah Patterson adopted dictum of man in Bluebrook and suggested the essential question for whether any class of creditors is getting too good a deal or too much value. And your lordships will see that Lord Justice Snowden uses the terms benefit and surplus synonymously. Your lordships should also have seen that we refer in paragraph 15 of our skeleton to Professor Patterson, who suggests that the term restructuring surplus is somewhat slippery and benefits of the plan is more straightforward, so we respectfully adopt that. Can I at this point just take your lordships to paragraph tab 115, which is Mr. Justice Richard's decision in Revolution, and I just wanted to show your lordships a similar observation made in paragraph 65 of that case.
Sorry, which tab?
Tab 115. I'm very sorry, my lord. If your lordships could just look at paragraph 65. And what Ms Justice Richards says, in addressing the question whether he should sanction the plan, it is appropriate to consider whether the plan fairly shares the benefits of the restructuring that are hoped to accrue by implementing the plan, rather than allowing the relative alternative to occur. That is sometimes referred to as the restructuring surplus, and I will use that expression as well, although I acknowledge it is something of a shorthand that glosses over the fact that in reality there is no surplus, as the plan involves many creditors not being paid fully in accordance with their current contractual entitlement.
But it's a surplus had between the plan and the relevant alternatives.
Yes, it is. It's the additional benefits that you get out of the plan. Yes? Generated or preserved by the plan.
Yeah.
Yeah, which is the next point I've got in my note, actually. So it's an organising concept, as we call it in 17.1, or a heuristic. So understood, there is no reason for the benefits to be purely financial. Indeed, in the context of a plan that is said to be interim and not distributive, the benefits will often not be financial. And it is that led the judge into error of concluding that there's no financial benefit, ergo there is no financial surplus. In the context of the vertical comparison in CVA's case law, the worse off is not limited to financial returns. And actually, I just want to refer to Mr. Justice Trower, tab 88 in Deep Ocean. Which I referred to without taking your lordships to it earlier. Tab 88. It's Mr. Justice Trower in Deep Ocean.
Deep Ocean, is it?
Yeah. Oh, sorry, my lord.
Deep Ocean.
Deep Ocean, and I wanted to turn to paragraph 35.
I don't know, for some reason, it's not in. I don't know why.
Was it not in tab 88, my lord?
No, tab 88 doesn't seem to have anything in it at the moment. For some reason. Not sure.
Excuse me while I scream. Has anyone got a clean one? Clean paper one?
Maybe somebody put it in. Maybe somebody appreciated that the bundles were suffering from so much bundle fatigue, that putting any more would lead to a collapse of every bundle.
Yeah, I'm so sorry.
Don't worry.
35, Mr. Justice Trower. Doubtless the starting point will normally be a comparison of the value of the likely dividend. And this would
we looking at
35, my lord. Or the amount of any discount to the par value of each creditor's debt. And this is what I clumsily tried to answer to my Lord Chief Justice Zacaroli earlier. So he says, you know, the starting point is normally going to be that. He says, however, the phrase uses any worse off, which is a broad concept and appears to contemplate the need to take into account the impact of the restructuring plan on all incidents of the liability to the creditor concerned, including matters such as timing and the security of any covenant to pay. So it's the all incidents point. And in our submission, the concept of worse off extends to the rights incidental to the liability. In other words, the rights a creditor has against the company in their capacity as such, and these may include non-financial rights. And we submit that the same, if not a broader approach, should apply to the horizontal comparison. And in this regard, the company in their skeleton, 46 to 47, try to theorise a different approach. We don't need a different approach. The existing conceptual framework is sufficient. So the next question is, well, what is the restructuring surplus? What are the benefits of the restructuring over the relevant alternative in this case? One, the purpose of the interim plan is to provide a stable platform to bridge to the holistic restructuring in RP2. Two, the plan provides the company with the opportunity and the associated advantages of pursuing an equity raise and RP2 outside of an insolvency process. 3, outside a SAR, creditors can have greater rights of access to the company and control over the interim process. These benefits of the restructuring or the restructuring, the benefits of the restructuring or the restructuring surplus. The Class A rights are rights forming part of the benefits of the restructuring. They are benefits generated under the plan that would not be obtained in the RA. In our submission, valuable rights. The company calls them merely ancillary in paragraph 42 of their skeleton. But having taken your lordships through those Class A rights, we find that submission surprising. In a SAR, no creditors will have any informational advantages, as your lordships have seen. They won't have control over liquidity that could put them in a better position to influence the outcome. And as your lordships have seen, the security may be disposed of. Even if the notion of surplus has to be reduced to financial value, the plan generates financial value over and above the relevant alternative. The company relies on returns under the plan and RP2 to satisfy the no worse off test. And those returns show that several plan classes receive returns under the plan and RP2 in excess of what they receive in the relevant alternative, and the company cannot disclaim that value for the purposes of the related horizontal comparison. But that is precisely what the company seeks to do. And at 296 to 298 of the judgment, the judge addressed the question of what degree of assurance there was that they'd have RP2, and he identified the test as being whether there was more than a fanciful prospect, and he concluded that was satisfied. So that being so, even focusing solely on financial value, the judge should have held the plan generated a restructuring surplus, namely the more than fanciful prospect that greater value would be available for distribution under RP2. Standing back, the judge's holding in this case that this case involves no restructuring surplus is hard to reconcile with what has happened. If the plan did not involve a restructuring surplus, in other words, if it didn't generate any benefits over and above the relevant alternative, it's hard to understand why the company is pursuing the plan and why the Class A creditors are defending it so vigorously. If there were no greater benefits under the plan compared to a SAR, there is no intelligible reason why the company and its directors would incur the costs of the plan and take on expensive super senior funding. Your lordships can see that in paragraphs 294 and 300 of the judgment. And if I can just refer your lordships to paragraph 19 of our skeleton, we include a quotation from a forthcoming chapter by Professor Merkel and others, several co-authors, which says, and I'm quoting, "It is the existence of this restructuring surplus that forms the very basic premise of any restructuring." In our submission, that is plainly correct, and the plan generates benefits over and above the relevant alternative of a SAR. And so the judge erred in holding, one, that there was no restructuring surplus or benefit, and two, it was not necessary for him to undertake a horizontal comparison between the Class A and the Class B creditors. And further, and as a footnote, even if one was to accept there's no restructuring surplus, that in and of itself is not an answer on horizontal fairness. In fact, in light of the alleged absence of any restructuring surplus, in other words, in light of the suggestion that there is no benefit produced by this interim plan, then when you get to the horizontal comparison, it takes more significance because the court has to determine whether classes of creditors are justifiably treated differently when it cannot be said that one class has contributed more to that benefit or surplus than the other. So it's simply, the company's position simply collapses back into the out of the money mantra, which we will address after ground 1B. And what I want to do now is turn to ground 1B, which is the share in the super senior funding point. So our ground is that the judge erred in concluding that no issue of horizontal fairness arose because plan creditors were treated equally as they could participate pari passu in the super senior funding. That conclusion failed to take into account the class rights given to the Class A creditors that would not be received by the Class B creditors, even if they participated in the super senior funding. And those are those rights I've identified. It's the liquidity control rights and it's the information and facilitation rights. Before addressing the flaws in the judge's reasoning, just a few points on the exercise of discretion to cross-class cramdown and to address a few points raised in the skeletons. We address the general principles in section C of our skeleton. The Class A AHG and the company suggest that the reference point for the horizontal comparison should not be the relevant alternative, but only the pre-existing rights. That is wrong for three reasons. First, the focus on pre-existing rights fails to take into account the true value of the rights should the plan not exist, in other words, the RA. And if I can just dip back into Adler, and just dip back into Adler, which is at 118, volume 6. The different, I want to go to 155 and just remind your lordships that when one comes to schemes and one is dealing with assenting classes, one doesn't generally make a horizontal comparison of the other assenting classes because they have voted in favour, the class has voted in favour, and then going through, I do not suggest we read 156 to 159 now, but I want to pick up at 159. Well, 159 I've taken your lordships to, and your lordships have seen that the reference point is the position of creditors in the relevant alternative.
Yeah.
And second, my second point is, given that the restructuring benefits are benefits over and above the RA, the question of whether there's been a fair distribution must start with a comparison of how the two groups are treated in the RA. And if there is a difference in the position, that is what has to be justified. And in our submission, when considering whether a restructuring plan is fair, it is important to, first of all, identify the benefits derived under the plan when compared to the relevant alternative. Secondly, assess whether the allocation of the benefits under the plan as between assenting and dissenting classes accords with the relative entitlements of those classes under the relevant alternative.
Yeah.
And then thirdly, if they do not, consider whether the difference in treatment is justified. So additional rights under the plan, we've already seen the additional rights given to the Class A creditors arising under the plan. Difference in rights do not, second point, we have seen that these rights put the A class creditors in a better position than they would be in the relevant alternative, especially when compared to the rights of the B creditors, because they would all be in the same boat. And then I come to whether or not there's a good reason for difference of the treatment.
Before you get to that,
Yes.
you may be coming to this, but
No?
your key point, leaving aside information rights at the moment, your key point is that the A's are given, you say, a right to veto the new lending.
Yeah.
Or it's dependent on their support. So they have the right to stop this
It's a
whole thing.
much better way of putting it, my lord.
Well, that's your point, I think.
Yeah.
The judge's answer to that was, well, but they already have that right. It may be packaged differently, but under the existing suite of documents, they essentially have that right already. You haven't addressed that. You may be going to, but it may be that your point is actually because that right doesn't exist in the SAR.
That is exactly the answer.
Really? That's it.
Well, your lordship says really with surprise, but that is the answer. That they don't have that right in the relevant alternative. Let's just strip back. What are we talking about? We're talking about whether the benefits of the plan as compared are shared equally. And the benefits of the plan is that you don't go into special administration. If you go into special administration, your lordships have seen what their rights are. So one of the benefits of the plan over and above special administration is precisely what your lordship has identified. They've got those rights.
Is it a benefit of the plan if they already have that right?
Yes, it is, because the plan keeps you out of special administration. My lord, your lordship should be under no illusions at all that absent this plan, the company will go into special administration. There's no question about that, because there will be events of default, it will go into standstill, and we have been told ad nauseum that the directors will then ask the Secretary of State and Ofwat to petition for administration. So that is what is going to happen absent the plan. So what does the plan do? What the plan does is it gives you this extended platform, if I can put it like that. And in the extended platform, and only in the extended platform, the Class A rights survive. So it's not right to say they have already got those rights, because those rights will not exist in the context of the SAR. And if you don't have this plan, this company will go into a SAR. So that's one of the things the judge got wrong, is you can't say, well, they've already got those rights, so what's the problem? Because what you've got to compare, what you've got to look at, is the benefits that arise from the plan. And the major benefit that arises from this plan, and it's identified in the passage I showed your lordships at the very start in the explanatory statement, is it keeps this company out of a SAR. And so you have to ask yourself, what are the rights of the A's and the B's in a SAR? Your lordships have got that point. You then ask yourself, what are the rights? And in a sense, what one's doing, my lord, is what are the rights that continue to exist, if I can put it that way? What are the rights that continue if this platform is continued? And your lordships put to me, well, they've got these rights already. They wouldn't have these rights under a SAR. And that really is critical, because the restructuring benefit is the benefit that derives from continuing with this platform. Everyone agrees with that? Can I get this out before your lordship? The continuation of this platform, and one then asks, is the way those rights are shared fair? And then we go and we ask ourselves, what are the rights that the A's are being given? And your lordship's got them. They've got those liquidity rights. That's not, it's simplistic to say that's under an existing contract, because those rights are being given to them. And then they've got the information and facilitation rights. Those rights are given to them under the plan. Now, to say the justification is that if this company was not in any sort of financial difficulties and we were not looking at a plan, the rights of the A class, and indeed the rights of the B class under the security, would give them a number of rights. And so you ask yourself, what's wrong then with them getting the same rights under the plan? That's not the question. The question, and in fact, my lord, the point your lordship makes goes to this. one's identified what the benefit of the plan is. It is the continuation of this platform. One then looks at how that benefit is shared, and one has seen that there are different advantages to the A's and the B's. And one then goes on to ask the question, is it fair that there should be this different treatment? Can you justify this different sharing of the restructuring surplus or the benefit of the plan? And your lordship's point, it isn't that they've got these rights and it should be allowed to continue. The question, which is a question Mr. Justice Leech did not address, is you ask yourself whether, in the context of what is being put in by everybody to the plan, is what each of the creditors are getting fair and justified? Sorry, my lord.
I mean, the point my lord raised with you, I mean, part of your argument, if I've understood it right, is that, is that in an SAR which the judge found was the relevant alternative, this, if you like, restriction on rights of information and so on wouldn't exist.
The additional rights would not exist, no, my lord.
The additional Class A rights would not exist.
Yes.
So on the basis that they're relevant, they are relevant what? For considering whether you are any worse off under the scheme. Is that,
No, that's a slightly different test. This is
Which
question of whether
it's
it's
probably the
fair.
same question, which is which
because
bit of the
otherwise the
statute.
judge had no jurisdiction if that
No.
if that's the argument
Yeah.
to make the
No,
to
my
deal
lord,
with the approval.
Which bit of the statute are you addressing in terms
Fairness.
of non-compliance?
fairness,
Just the fairness point.
which is the discretion point, my lord.
It's just
Yes.
all to do with the discretion.
This is all to do with the discretion and fairness and getting to the right. What I've tried
So
to do.
so you're saying it was unfair because under an SAR nobody would have any of these rights, whereas under the plan the Class A creditors have those rights, Class B don't. Even though, as things stood, the Class B didn't have the rights.
Well, the Class B did have. That's one of the reasons why I
They're
showed
worse
you.
off.
We had certain rights. In other words, you've got to compromise our the rights that I showed you at the very start. Okay, so your lordship's got that point. The other thing when it comes to fairness that your lordships need to bear in mind is that these rights to the Class A's, and I was, I hope, careful in showing them to you. So your lordship's got, we've got the entrenched rights and we've got the maturity rights. Your lordship's got that, right. These additional rights are given to Class A creditors even regardless of whether or not they participate in the super senior funding, which your lordships have got.
But are you? I'm still not clear about this. Sorry, it's my confusion.
No, it's my fault.
But are you? Is your position then that the jurisdictional condition A was satisfied in this case? So that, in other words, you were no worse off under this scheme than you would be in the relevant alternative.
Well, yeah, no, I get that, but he's asked me for a direct question. Well, we didn't appeal it. No, the point is you can be no worse off, but it can still be unfair, just to be clear. And I haven't appealed that point.
Well,
So
my
I can't go
understanding
back
of
to
your
it.
answer to me, and I think you've just confirmed that in answer to my lord, is that this is all to do with the fairness in the exercise of the discretion.
Yes,
It's
it
not
is.
to do with it's not an allegation of non-compliance with condition A.
Correct. And my lord, the reason why I've shown you no worse off, and I hope I haven't confused, because one of the problems with the way this statute has been treated is that it's been a discussion of what other judges have said in the cases as opposed to looking at the statute far too much, is I've shown your lordships that test so that your lordships can see, and we'll get to it in 1C, is you don't answer the horizontal comparison points by saying you're out the money.
No, but you I thought your argument earlier on, I'm sure it's me, was that the out of the money way of characterising the no worse off clause was not an appropriate way of dealing with 901G3 as opposed to C. I think you accepted
Yes.
that the class
No.
rules about disenfranchisement that would seem to be appropriate. But I thought your argument in part was that it wasn't an appropriate way of interpreting the words any worse off.
My lord, your lordship is absolutely right. And one of the problems is when your lordship goes back to look at the passages from Mr. Justice Snowden that were then picked up by Mr. Justice Leech, he elided that into the fairness test. And he said, well, it's therefore not surprising that when you come to fairness, their voice shouldn't count for very much, which all goes to...
But I'm sorry to...
Yeah, no,
I
no,
do
that's fine.
need to finish.
Was that
So
not right?
are you accepting then that the no worse off test is simply if you like an in or out of the money
No.
test or not? You're not.
No, absolutely not, my
You're
lord.
saying that includes other things.
Yes.
And it includes the disadvantage that you say you suffer under this scheme compared
It
to
could.
an SAR of not having access to the information. It's as broad as that, is it?
Well, it depends whether or not your lordship takes the view that that is a disadvantage, whether that makes us
Well, I'm not
worse
taking
off.
any view, I just want
as a-
to know what your submission is at the moment.
Well, my submission is, and to be crystal clear, no worse off does not equal out of the money. It is it is broader than that. And there is then the question of fairness, which is horizontal fairness, where you're comparing what each has contributed and what each gets out. And what you can't do is you can't elide those two. And in the criticals paragraph that I showed your lordship of from Justice Snowden, that's picked up, I think it's 248,
249.
249, that elision is made.
Well, I'm just about to ask you that question because
Yeah.
paragraph 249 of Mr. Justice Snowden's judgment in Virgin Active is actually endorsed by this court in Adler, albeit the same judge, but my Lord and Lord Justice Nugent agreed with the judgment. And unless you're going to say this is all obiter and not part of the ratio, why isn't that binding on us? I'm speaking for myself. Paragraph 249 of Virgin Active seems to me to make perfect sense.
Well, that's never a helpful place to be. But what I'm going to
Well,
do...
you might say that I shouldn't proceed on that basis given the nature of the legislation we're dealing with, but I mean, that is the fact of the matter. He makes the very point about fairness in the context of
Well, I'm going to duck it again because we've agreed that my learned friend Mr. Thornton's going to deal with this. So
okay, that's fine. We'll leave that for him. In that case.
we've tried not to overlap.
Well, so far you've done pretty well, Mr. Phillips.
Anyway, can I then?
On the timing. It's slower than you thought.
It has gone more slowly than
Have we
than
got
I
a copy of this timetable, or is it all being kept on your side?
No, there is no particular copy of it. It's just that I knew that that was what I was supposed to do.
So how much longer have you got?
Well, one of the problems that I've got in this case, and please forgive me for going back over the history, is throughout I wasn't given enough time for anything. We had 1 hour
Well,
and
don't start.
So you've got
moaning
that.
about
But anyway,
Get over all that with the
so I'm
mouthful.
really nervous about cutting anything down.
No.
What I can tell your lordships is I will finish certainly, I don't think I'm not, I think it's about 15 minutes actually.
Okay.
Because I don't think, no, I'm not taking your lordships to any more authorities.
okay.
I've tried to be really economic with the reference to authorities. So I think my lord's 15 minutes
All right, well, you're not too bad, though. Anyway, you've got another 2 or 3 minutes, so it's...
Yeah, so the next point I was going to make is that having done that, we have to consider whether there's a good justification for a difference in the treatment. And I've made the point that your lordships have got the stable platform point, and I showed your lordships, they rely on 3 things. They rely on the super senior funding, they rely on the extension of maturities, and they rely on cancellation of undrawn facilities. And that's in B1 of our skeleton, but the first point to make is in the context of those particular contributions, which are the only ones that they identify, the fact that the Class A's rank higher than the Class B's is not relevant. None of those features justify the Class A's obtaining additional valuable rights, and I'll just hit them very quickly. The super senior funding, your lordships have got the point, both the Class A's and the Class B's contribute to those. The extension of maturities, again, your lordships have seen there are 2 Class B debts and 2 Class A debts, and your lordships know that in Adler, Lord Justice Snowden made the point that extending maturities is of economic value in itself. Well, that is being done. It's the near dated debts that need to be extended. So that's contributed to equally by us and the A class. And I just refer your lordships to paragraph 27, in which we say the judge misunderstood that particular argument. Cancellation of undrawn commitments, that really is not important. And then there are other assisted certain contributions, which I'm guessing your lordship would like me to return to after the short
I
adjournment.
think so. So we say 2 o'clock then, please.
Thank you.
All rise.